Florida lawmakers are considering a proposal that could bring new fees and increase state oversight to homeowners associations across the state, and it's already sparking strong reactions on both sides. At the center of the proposal are two Senate bills that would significantly change how HOAs operate in Florida. The legislation would create a new state office of the HOA Ombudsman, designed to help homeowners better understand their rights and provide oversight in disputes involving HOA meetings, elections, and governance procedures. Supporters of the proposal argue that HOA complaints have been rising, especially around transparency, access to records, and accountability of boards. They say many homeowners feel powerless when disputes arise, and the Ombudsman Office would serve as a neutral resource to ensure rules are followed and rights are protected. From this perspective, increased oversight is seen as a way to bring consistency and fairness to HOA governance statewide. But there's another side to this. To fund the new oversight structure, the proposal would impose an annual state assessment on homeowners associations. Under the plan, most HOAs would be required to pay a per-parcel fee each year. While the fee itself may seem small on paper, critics argue that it ultimately gets passed down to homeowners through higher dues. The proposal also includes penalties for non-payment, including late fees, and potential restrictions on an HOA's ability to take legal action if the assessment isn't paid on time. Opponents say this could put associations in a difficult position, especially smaller communities that already operate on tight budgets. HOA leaders and real estate groups have raised concerns that more state involvement could undermine local control. Many associations manage amenities like pools, landscaping, roofs, and shared infrastructure, and they argue that additional fees and regulatory pressure could divert money away from maintenance and long-term reserves. Some also worry that state oversight could slow decision-making and create compliance risks for volunteer board members. At the same time, the proposal comes amid broader efforts in Florida to rethink HOA authority altogether. Separate legislation would give homeowners a clearer path to vote on dissolving their HOA if enough residents agree. Supporters of that idea say it empowers homeowners who feel trapped by restrictive or mismanaged associations. Critics counter that dissolving an HOA can jeopardize shared amenities, property values, and long-term community planning. Together, these proposals reflect a deeper debate happening across Florida. How much power should homeowners associations have, and how much oversight should the state impose? For homeowners frustrated by opaque boards and limited recourse, the changes promise accountability and protection. For associations focused on self-governance and cost control, the proposals raise concerns about rising expenses and state interference. If passed, the new fee structure and oversight provisions would take effect in mid-2026, giving associations time to adjust, but also creating uncertainty about future costs and compliance requirements. For Florida homeowners, HOA board members, and property investors, this is not just a political issue. It's a practical one that could affect monthly dues, governance rights, and long-term property values. If you have questions about how potential HOA changes could impact insurance coverage, liability, or property-related risks, or you want to book an appointment to discuss your situation, visit hendricksonins.com for guidance and support.